It is a trial lawyer's job to educate jurors and tell them what they need to know in order to decide cases. Despite this, there are many things, true things, that lawyers are not allowed to tell jurors directly in statements to the jury or indirectly through testimony of their witnesses. Lawyers know these things, though, and I thought you might like to know some of these things as well. Number one, a lawyer can't tell the jurors anything that happened during settlement negotiations. He cannot let the jurors know, for example, when asking them to make the defendant pay his client $100,000, that the defendant already agreed that $80,000 was fair prior to the trial. The reason for this is that you want settlement negotiations to be very open. You don't want to damage a negotiation session because someone is afraid that what they say will be repeated to a jury if you don't strike a deal. Number two, in Idaho, a lawyer can't tell the jurors that the defendant has insurance. In many other states, he can. Because we're not in a trial setting right now, I can tell you as members of the general public that any defendant on trial in a personal injury case probably has insurance. If he didn't, the plaintiff would not be wasting his time in a trial attempting to get a judgment against a defendant that cannot afford to pay. Idaho jurors are instructed that they cannot consider whether a defendant does or does not have insurance when they are deliberating. Which brings me to the third point. A lawyer for the plaintiff cannot tell the jury how rich the defendant is, and the defense cannot tell the jury how poor the defendant is. If a lawyer does either of these things, the judge may order a mistrial. In one case I tried, the defense counsel made a statement in closing argument about the poverty of his client. After the jury gave a small award to the plaintiff, on my motion, the judge doubled the verdict in favor of the plaintiff, and that was fair. Taboo number 4. A lawyer can't tell the jury that the defendant has been accused of crimes in the past. Accusations of crimes are not admissible. Certain convictions are admissible. If the defendant has been convicted of a felony or of a misdemeanor that's relevant to whether he's telling the truth, that conviction can be introduced if it happened less than 10 years ago. What about that felony conviction for fraud against the defendant from 10.5 years ago? No, that's gone, and the plaintiff can't use it against him. If the defendant was convicted of a felony fraud 3 years ago, but that charge was dismissed after he successfully completed probation, the plaintiff's lawyer can't tell the jury about that either. Telling the jury about a party's dismissed criminal charge under any circumstances is almost a guaranteed mistrial. Taboo number 5 is the golden rule. The golden rule of trial advocacy is that a lawyer cannot ask the jurors to place themselves in the position of his client. Oh, your lawyer would like to ask the jurors in closing argument, how would you feel if you had one big constant headache that lasted for 1 month like my client? Would you think it was fair for the defendant to pay you a certain sum of money for that headache and then walk away from it without any further consequences? No, your lawyer can't say that. He can give the jurors information during the trial that makes them understand how much the plaintiff did suffer, but he cannot actually tell the jurors to put themselves in his client's place. If he does that, the other lawyer will jump up and say, golden rule, and the judge will sustain his objection and instruct the jurors to disregard what the lawyer just said. Taboo number 6. The plaintiff's lawyer can't ask the jurors to punish the defendant. That kind of thing is only allowed in the rare case in which the lawyer is allowed to ask for punitive damages, and the judge has to give him permission to do so in advance, well in advance of trial. And there have to be facts on the record that show the defendant acted maliciously or with reckless disregard that he's probably going to hurt someone with his conduct. The lawyer can ask the jury to calculate the financial and non-economic losses, but punishment cannot enter the equation. Which brings us to taboo number 7. A lawyer cannot tell the jury the court will limit any award of non-economic or pain and suffering damages if your award exceeds the statutory cap on non-economic damages. In Idaho, as many other states have, we have tort reform, which limits the amount of pain and suffering damages an injured plaintiff can collect. And you can't tell the jurors that the judge will reduce that award if any portion of that exceeds $325,000. We may address some of the other things lawyers are not able to tell the jury in the future, but that's all I'll cover for now. Thank you for joining me. I'm Alan Browning with Browning Law, and I hope you have a great day.